Hello, everyone. Emachi yapi wanietu wichasa yatapi mato. My name is Winter Bear King. I am a Hunkpapa Lakota descendant, currently living on Piscataway land in the Baltimore, Maryland area. I started with the association as a NAGPRA trainer and transitioned to the Cultural Sovereignty Curriculum Development Project Lead position last August. My background is in American history and sociology, studying the impact of social perception on the rights and opportunities of historically minoritized and oppressed groups. And I am currently finishing up my master's in cultural heritage management at Johns Hopkins University. It is such a pleasure to be here in community with all of you today. Thank you so much for attending, and I will pass it on to Kay.
Thank you, Winter. Bonjour, kikenda so indashnakas, but I want me and down mengen dodem yut minipayu aki in Dochpia, wabin aki edayan, Gishben, Massachusetts. Hello, I am Kay Kikenda Matina. I am Bodewadami or Potawatomi. I'm a citizen of the Citizen Potawatomi Nation, and I am Loon Clan. And I am joining from Wabanaki, or the Dawnland, also known as Massachusetts. I'm the program associate for the association, and I am also a NAGPRA trainer, and I've been working with Winter and Basil since the very beginning of developing this training. Really excited to bring it to you all today. And I started this training as a newbie to NAGPRA, so I'm really excited to share my own personal growth as well as the growth of my peers with you all.
And hello, everyone. My name is Basil Stewart. I'm a museum practitioner currently working full-time as an NAGPRA coordinator in Virginia. I hold a master's degree, and my background is in museum studies and in public archaeology. And just like Kay and Winter, I've been with the association as an NAGPRA trainer since the beginning. Thank you again for joining us, and I look forward to engaging with you all today.
Thank you. So I just wanted to say before we begin that I wanted to give a disclaimer on language. So for the purpose of this presentation, we will refer to human remains as ancestors and cultural items as belongings. However, when quoting directly from the regulations, we will continue to use the wording directly from the law. This section of the presentation provides context for interpreting and understanding Subpart A of NAGPRA, the Act and regulations just generally. I will give you a brief introduction to Native sovereignty, federal Indian law, the canons of construction, the IRAC interpretation method, and general interpretation tips. It is my intent to provide you some help in contextualizing this work as non-lawyer practitioners. Most of us here in this room, this virtual room, are working with the federal law and regulations, but do not necessarily have legal degrees or legal backgrounds, even just an introduction to legal interpretation to carry out compliance. These tools and contexts, which have deepened my own understanding of the Act and regulations as a non-lawyer, are meant to empower you to find the solutions to issues and questions that come up along the way throughout the repatriation process. So before we begin, we would like to dive into this particular question of what does sovereignty mean? If you are comfortable, please share your response in the chat. We will take a couple of minutes to let everyone think about the question and share their thoughts. Power and authority from Shannon. I'd love to hear your input. Anybody?
We have Shannon's Harley said independence.
Ooh. Cece said self-determination. Amy mentioned the ability to make decisions for oneself. And Megan said leadership. Independence. Autonomy. Then I hope I'm pronouncing this right. Is it Neve? Sovereignty is Indian self-determination, self-sustainability, and independent tribal governments. Thank you all for putting in your answers. We're seeing a lot about self-determination, autonomy, decision-making, choice, self-governance. Ooh, respect. Yes. Thank you all for your participation. So some of the themes that are coming up are part of what Native sovereignty means. Native sovereignty is the inherent right for Native nations to govern themselves and make decisions about their people, resources, cultures, and lands. Indian law is interpreted differently from other bodies of US law because of the political protections afforded that respect and protect Native sovereignty. This must be accounted for when interpreting and legally complying with NAGPRA. Native sovereignty is present in some of the US's most influential documents, such as the Indian Commerce Clause of the US Constitution, which is Article 1, Section 8, Clause 1. And one of my colleagues will put that link in the chat for you. So federal Indian law, including NAGPRA, is shaped heavily by Native sovereignty. So federal Indian law. What is federal Indian law? According to the University of Alaska at Fairbanks, federal Indian law involves a distinct body of law that relates to the legal relationships between the federal government and Indian tribes. It is dynamic, evolving, and encompasses several hundred years of federal policies and interactions with tribes. The sources of federal Indian law include principles of international law, the United States Constitution, treaties with Indian tribes, federal statutes and regulations, such as NAGPRA, executive orders, and judicial opinions. NAGPRA fits under the umbrella of Indian law, and Indian law is influenced by the canons of construction. And there is a link for more information from the University of Alaska Fairbanks if you are interested in looking into that. So the canons of construction. The canons of construction are traditionally used by judges to interpret law in court cases. But here in our particular context, as non-lawyer NAGPRA practitioners, the canons can serve as a resource in understanding and enacting NAGPRA. I want to be transparent that there are more canons to consider than the one that we are going to focus on today. But the main takeaway in our discussion is the Indian ambiguity canon. Ambiguities in laws and agreements should be construed liberally in favor of tribes. Ambiguities in laws and agreements being interpreted liberally in favor of tribes are of particular importance to NAGPRA. Common law systems and Western ideology are not necessarily always aligned with traditional Native beliefs. And NAGPRA fundamentally seeks to protect and restore ancestors and cultural items deeply influenced by worldview. There are areas within NAGPRA with room for interpretation to account for this difference in belief. For instance, NAGPRA repatriation requires museums and federal agencies to protect sensitive information that is shared during the repatriation process, even after they relinquish possession or control of an ancestor or cultural item. And what is considered sensitive information is determined by the consulting party. It's not listed specifically as one type of information, such as the location of a burial site. Ambiguities like this example in NAGPRA allow room for the diverse lifeways and similarly specific types of information like what is sensitive information to be interpreted by the tribes. Worldview impacts our interpretation of terms and concepts, and in turn, these terms and concepts impact what NAGPRA protects and restores within the legal framework. In dealing with repatriation of Indigenous ancestors and cultural items, it is imperative as practitioners that we actively listen to and engage with worldviews we may not understand ourselves or previously had access to as an insider with that lived experience. I would like to draw your attention to a quote from De La Hunt, and this article will also be put in the chat for you to check out yourself for further reading. Inconsistent use of the canons of construction in interpreting Indian treaties and statutes jeopardizes Indian rights, Indian interests, and the federal Indian trust. So we're all here today with the goal to contribute to NAGPRA's success, which prioritizes the rights of sovereign Native nations to maintain and make decisions about their people and cultural items with respect to the unique relationship between Native nations and the federal government. Native sovereignty should be considered in all decisions throughout the NAGPRA processes. The Department of Interior makes this clear in the final rule published on December 13th, 2023. A link will be put in the chat to see their support of the Indian ambiguity canon. And just a reminder that the final rule is an excellent resource if you have questions about the meanings of specific words or the intent behind the new regulations. I highly recommend getting comfortable with that publication. So with this lens in mind of respect to Native sovereignty, we will now explore a method for interpreting documents called IRAC-IRAC. So what is the IRAC method? This stands for issue, rule, analyze, and conclusion. So when we are thinking of IRAC, think of it as the scientific method. This is a process that will help you identify the issue or the question and applicable rules, analyze the issue or question in relation to the law or regulation, and create a conclusion based on your findings. So issue. What is your issue or question? This is where you narrow down what you are trying to solve or find an answer to. Maybe you're wondering, how can you determine who's the most appropriate requester when multiple nations have cultural affiliation. It is important that in this particular step that you communicate your question or answer, your question or issue in direct language to keep this question specific. It's similar to writing a paper and doing research. If the information is too broad, it's going to be really difficult to narrow that down. So the rule. This is the step in which you find the applicable rule and explain it in your own words. What does the rule mean? In NAGPRA, we may refer to multiple documents related to the issue. This means you may be looking in the regulations, the Act, or the Federal Register with the final rule and comments published by National NAGPRA, but it should always start with the particular document you are trying to interpret. At this point in the process, we are simply stating the general rule and its meaning and not yet applying it specifically to the circumstances of our particular instance. The next step is to analyze. In this step, we analyze the rule in relation to the specifics of our issue or question. And the example I gave for determining the most appropriate claim in competing claims for repatriation, we would compare the facts of the specific situation to what the regulation actually says. In this step, it's really important to consider all the available information, including the specifics of the situation and all relevant legal information that is related to the rule. If there is confusion on a term or concept, this is a great time to consider how the final rule comments from National NAGPRA figure in. One particular example that has been coming up lately in conversations locally has been the definition of lineal descendant and what it means to be a known individual. While the regulations are not as specific, the final rule gives further clarification on the applicability of these terms. So the last step in the IRAC method is to write a conclusion based on the analysis of the facts and the rule. Now it is important to remember it is possible to have more than one plausible conclusion. Interpretation-wise, this is where I would check in with myself to reflect on whether this conclusion is aligned with the canons of construction. I might consider, is this conclusion liberally interpreted to the benefit of the Native nation? Is this interpretation how Native nations interpret the Act or the regulations? With this in mind, I would like to give you a few more rules and tips that have really helped me in learning more about NAGPRA. So the four-corner rule states the interpretation of a legal document, like a law, a case, or a contract, should be done within the four corners of the document. While it is helpful and useful to evaluate all relevant documents when interpreting law, this begins with interpreting the actual document itself, as I had mentioned earlier, and then moving on to other relevant documents. Another important rule to consider is the harmonious construction rule. So this is where we want to make sure that all the different parts of the Act and the regulations, that they are interpreted in a way that harmonizes all the different parts together. If there are issues or inconsistencies, they should be interpreted in a harmonious way and not arbitrarily or piece by piece. One of the ways that I can check in with myself to make sure that I'm interpreting it in a harmonious way is looking back to the purpose. Moving on, just a few more tips before I move on to a different subject. I wanted to talk to you about location. So location is incredibly important, and being able to orient yourself within the document that you are looking at. So understanding the table of contents, the introduction, definitions, and subtitles, those are important parts too. So with the table of contents, this tells a story of how to understand the law. And just to use NAGPRA as an example, you can look at the table of contents and it's going to almost linearly be able to orient you through the process. The introduction lays out important concepts and the purpose of a law or regulations. These guiding principles and the purpose directly influence how a legal document should be interpreted and how the information should be prioritized. For instance, if we're looking at NAGPRA, the information that is in the introduction, such as the purpose, is going to have more influence over the rest of the regulations compared to maybe Subpart D, that is only specific to the review committee. And when it comes to definitions, I know it doesn't seem quite as important because there's a lot of times that we interchange words regularly in just everyday conversation. But when it comes to legal terms, it's really important to use the exact terminology. Definitions for legal terms are crucial to understand because legal terms have very specific meanings that impact how the law is interpreted. For instance, the newest regulations defined an Indian tribe as needing to be federally recognized under NAGPRA. This impacts who museums and federal agencies must or may consult with during repatriation. At the same time, the definition for lineal descendant does not require federal recognition status. Understanding the definitions helps you understand applicability and scope. And as I had mentioned earlier, location absolutely matters. And being able to look at the subtitles and titles helps a practitioner coordinate where they are in the regulations or the act. These are considerations to keep in mind as we move through the rest of the presentation today and you explore the regulations and get better acquainted with them through your own NAGPRA journey. So, where does NAGPRA fit into this discussion on Native sovereignty? Native sovereignty impacts all federal Indian law, including NAGPRA. NAGPRA should be interpreted liberally in favor of Native nations under the canons of construction. IRAC can be used along with the canons of construction to better realize the purpose of NAGPRA, which that's what we're all here for. If you're coming up against issues and questions, remember to ask, how might Native nations interpret this? As was mentioned in regards to the harmonious construction rule, we must learn NAGPRA holistically to give us the best foundation to do what we all need to do to become experts in the purpose of the law, and this is nestled into Subpart A, General. Remember how those subtitles can coordinate us. And while general may seem insignificant or boring, you can't really understand any piece of text without first knowing the vocabulary. I will now turn it over to Kay, who will get us started on building our NAGPRA vocabulary in Subpart A of the NAGPRA regulations.
Thank you, Winter. So today we're going to spend some time diving into Subpart A of the NAGPRA regulations, as was mentioned. Please follow the link that my comrade Basil is going to put in the chat for us to view Subpart A of the regulations. We encourage you as we go through this law in depth to read along with us. Whenever we have questions about anything in relation to NAGPRA, the first place we go is to these regulations and the act. So please follow along with us. So Subpart A is arguably, as Winter mentioned, one of the most important sections of NAGPRA because it covers the entirety of the law. It is in Subpart A that we learn the very purpose of the law and who it is intended to serve. So the purpose paragraph of the regulations is the very first paragraph you'll come to. It is significant that all of us as learners, both new and experienced, regularly revisit this section to ensure that we are grounded in the intent and goals of NAGPRA. There are three main purpose sections within that paragraph. They are to protect and restore ancestors and belongings, that consultation is a requirement throughout the NAGPRA process, and that the Act and regulations require deference to Native traditional knowledge. So first and foremost, NAGPRA provides a systematic, well-outlined process to protect and restore. By protect, the regulations speak to the legal obligation to protect ancestors and cultural items in the ground. These are the graves protection provisions, which we aren't going to get to in this training, but teaser for the future. Ancestors and cultural items within institutions during the repatriation process, sacred and culturally sensitive information, Native traditional knowledge and expertise, and Native nation consultation rights and sovereignty. The need for protect in the purpose echoes the past harm, excavation, looting, and destruction in the face of development, which unfortunately is still a persisting issue today when it comes to protecting sacred places, ancestral homelands, and grave sites. Note that this language mirrors the definition of archaeology itself, which is defined as the systematic destruction of a site. And the Society of American Archaeology's definition also states that once a site is excavated, it is gone forever. In this train of thought, the language of restore in the purpose centers the obligation to return ancestors and cultural items to lineal descendants, Native nations, and Native Hawaiian organizations, or NHOs, for the benefit of lineal descendants, Native nations, and NHOs, and not for the benefit of institutions. Again, the need for restore in the purpose connects back to the past conditions that inspired NAGPRA's creation, the theft of belongings and ancestors that now need to make their journeys back home. And for that, NAGPRA provides this systematic process to make this purpose actionable. The parties who initiated the creation of NAGPRA saw a problem which needed to be fixed, and the systematic processes for repatriation and disposition in the regulations provide the remedy. You can't feed the fire without first learning how to care for a fire and where to gather the supplies you'll need to keep that fire going. The regulation provides clear step-by-step instructions and outlines the timelines, deadlines, and the consequences of non-compliance.
The second point of NAGPRA's purpose states that NAGPRA requires consultation with lineal descendants, Native nations, and Native Hawaiian organizations. The regulations provide us with a clear and specific definition for consultation within NAGPRA, which is as followed. Consultation is the exchange of information, open discussion, and joint deliberation made between all parties in good faith and in order to seek, discuss, and consider the views of all parties, strive for consensus, agreement, or mutually acceptable alternatives, and enable meaningful consideration of Native American traditional knowledge of lineal descendants, Native nations, and NHOs. In the final rule, DOI describes consultation as critical, central, and continual. Consultation must be understood as intrinsic to the whole of the NAGPRA process. And without consultation, there is no repatriation or disposition. It's also very important to understand that consultation within NAGPRA is not equivalent to consultation that is done in other situations. This means that the experience that you may have with consultation in other roles, such as during a cultural resource management project, should not direct the way you consult in NAGPRA, because the regulations have provided us with a great and very clear specialized definition. You should always return to the regulations for guidance on how to consult for NAGPRA and not rely on your past understanding. At the end of our presentation today, we're going to open up discussion about your own experience with NAGPRA consultation.
The third point in the purpose is that these regulations require deference to the Native American traditional knowledge of lineal descendants, Indian tribes, and Native Hawaiian organizations. So what is deference? It should be noted here that this deference for Native nation sovereignty and their traditional knowledge here covers the entirety of the law. When we get into the nitty-gritty of other sections in the law later on, deference has a very specific application. So a major change to the final rule made in December of 2023 is the phrasing of deference to lineal descendants, Indian tribes, and NHOs, which was added in the purpose paragraph. Deference, meaning the federal law acknowledges and respects the legitimacy and authority of Native nations and likewise Native traditional knowledge. Native traditional knowledge means knowledge, philosophies, beliefs, traditions, skills, and practices that are developed, embedded, and often safeguarded by or confidential to individual Native Americans, Indian tribes, or Native Hawaiian communities. This point on often safeguarded by or confidential gets back to our obligation to protect. So any sensitive information that might be shared throughout the repatriation process and in consultation is also something we need to consider, in that many Native traditional beliefs are considered confidential, and we need to ensure that we're respecting that sovereignty over that knowledge. Native American traditional knowledge contextualizes relationships between and among people, the places they inhabit, and the broader world around them, covering a wide variety of information, including but not limited to cultural, ecological, linguistic, religious, scientific, societal, spiritual, and technical knowledge. Native American traditional knowledge may be, but is not required to be, developed, sustained, and passed through time, often forming part of a cultural or spiritual identity. And importantly, Native American traditional knowledge is expert opinion. So to provide an example, I'm not sure why, but my slide likes to double click every once in a while, so you guys get a little sneak peek of the slides to come here and there. But I wanted to give an example of Native traditional knowledge that was shared with me. It's written by Dr. Lisa Brooks, who's a Benaki. And so if you would like to read more, I highly encourage you to go look at Dr. Lisa Brooks' research and her authorship on this topic. But we're going to be talking about Mount Sugarloaf, also known as Kitsiamisqua, or the Great Beaver. So in this story, and I'll be very, very brief, a lot of these stories can last weeks, hours, sometimes months. They take really, really long time to share. So this is really, really brief. So Kitsiamisqua is a giant beaver who once roamed this land that I currently live in Western Massachusetts, or Wabanaki, the Dawn Land. And this great beaver built a dam that dammed up the waterway. And it caused a lot of issues, as you can imagine, for the villages that relied on this riverway for food, for their shellfish, for fishing, for farming. And when this beaver, the great beaver, Kitsiamisqua, came in and built this dam, it flooded. And so they no longer had access to where they would fish and farm. And so the people went to the great beaver and said, hey, you're causing a lot of issues for us. Could you move somewhere else? Could you allow some of the water to pass through? And the beaver was very stubborn. Said, no, I like it here. I'm not going anywhere. And so after several times of trying to do this, the people then went to the giant Habamak, who lived in this area. He was a giant deity that cared for the lands, and Habamak agreed to help the people. And so he took with him what some of you, if you're familiar with belongings from the Northeast, he took with him what looks like a Penobscot root ball club. If you don't know what that is, you can Google it. You'll find lots. But he took this item with him just in case. He was hoping to have a conversation with Kitsiamisqua and try to talk the great beaver into moving, or at least allowing the water to pass through. And again, the beaver refused. And so then there was a great battle between Kitsiamisqua and Habamak. And in the process, Habamak ended up slaying the great beaver. And so he brought his root ball club down on the beaver's neck and broke it. And here you can see Dr. Lisa Brooks, who is pointing to Kitiamiskua. This is the beaver's head, and then this is the rest of the beaver. So she is gesturing to where Habamuk's club came down and severed the beaver's neck, with Judy Dow, who is an Abenaki elder and master basket maker. You can see here on the bottom, this is what is now called the Connecticut River, also known as the Quinetiqua River. And on the other side, these are the Holyoke Mountains. So the really cool thing about the story is it seems fantastical and like a children's storybook kind of story, but it's a story about deglaciation that happened between 20,000 years ago and 10,000 years ago. And what you're seeing on this side are the glacial moraines. So these are mountain ranges, including the Great Beaver, that were created as the glaciers retreated off of what is now Massachusetts. And it caused these mountains to build up along the edges. And as the glaciers retreated, they left behind smaller glaciers that kind of floated up and down the riverways. And that's what carved out the Connecticut Riverway. And these sort of tiny glaciers would have been covered in mud and debris, so they would look brown like a giant beaver. And so this story is a story of deglaciation that happened 10 to 20,000 years ago. And it's a story that's been told for generations. And it's a story about the relationships between people and how that relationship stretches back long before what we would think living memory might go. And on top of that, it's this connection to the incredible fertility of the glacial floodplains and that relationship between land itself, between our neighbors, between other Native nations that share similar stories. And it's a story of relationships with specific cultural heritage items. We heard in the story about the weapon, the Penobscot Club. And for those of us working in repatriation in the Northeast, we are familiar with those. We have often seen those. And so this kind of story is the example of how Native American traditional knowledge can be key, especially because it is considered expert opinion. And it can provide insight in determining if an excavation or taking of an ancestor or belonging was done so without consent of the Native nation or individual lineal descendant. In the example of Kitiamiskua, we can see that Native traditional knowledge can be carried for thousands of years. And it can include knowledge about specific ancestors and belongings, Native nations' ties to homelands, and relationships to one another and our more than human relatives. This is important to understand if the institution you work for has applicable collections or holdings under NAGPRA.
So now that we understand the purpose of NAGPRA, the applicability section of 10.1 lets us know who is required by NAGPRA to take certain actions and who and what the regulations pertain to. And again, we recommend following along in the regulations with us. We have that link in the chat. So first, NAGPRA applies to museums and federal agencies and requires that these entities take certain actions and meet the deadlines that are outlined in sections B and C of the NAGPRA regulations. NAGPRA provides us with a specific definition for what is considered a museum. And this is any institution who has received federal funding and has possession/control or custody of a holding or collection. And we will break down what that means further in the following slides. So if you have the question, does NAGPRA apply to my institution? The answer lies in whether or not your institution has received federal funds and also has a holding of Native American cultural items or ancestors. Native nations, NHOs, and lineal descendants are not required to participate in the NAGPRA process unless they also meet NAGPRA's definition of a museum in a special context. However, it's important to remember that successful repatriation and disposition is dependent on Native nations and NHOs working together with museums and the federal government. In the definition of museum, I brought up the terms possession/control and custody. Possession/control means having a sufficient interest in an object or item to independently direct, manage, and oversee or restrict the use of the object or item, while custody means having an obligation to care for the object or item, but not sufficient interest in the object or item to constitute that possession/control. So these definitions are a little wordy and a little complicated, so I have some examples. So for one example, a museum which is loaning out objects, or which is loaning in objects from another museum, most likely has custody of those objects, but not possession or control. Another example would be a museum which is a federal repository for the federal government's collections. In this instance, the federal government has the possession or control, and the repository has custody. The entity which has possession/control is the party responsible for NAGPRA compliance. However, any entity with custody of ancestors or cultural items still has a responsibility to follow the duty of care requirements. And we're going to learn more about those later on in the presentation. The answer to the question, do we have possession or control, should be one of the first things a museum finds out regarding the ancestors and cultural items in their care. Another term that was included in that definition for museums is holdings or collections. For the purpose of NAGPRA, a holding or collection means an accumulation of one or more objects, items, or ancestors for any temporary or permanent purpose. Ultimately, this encompasses everything within the museum, whether it be on exhibit, in storage, educational material, on loan to other institutions, or on loan to individual persons. We strongly encourage museums to cover all their bases when determining where in their institution cultural items and ancestors may be located. A holding or collection can include ancestors or human remains, and cultural items, which are categorized as funerary objects, which may be associated or unassociated, sacred objects, or objects of cultural patrimony, according to the Native American traditional knowledge of lineal descendants, Native nations, or NHOs. The determination of which of these categories an object falls under can only be made through consultation. And note that the definition states that it is according to Native American traditional knowledge. Prior to consultation, a museum may have an opinion about the designation of an object, but the conclusion is at the discretion of the culturally affiliated Native nation, NHO, or lineal descendant. So again, we can see here how critically important consultation is to all aspects of NAGPRA.
Thank you for that, Basil. So we're going to be moving on to a very important concept, which is right of possession. This is a bit out of order from the regulations, but this is so important that we wanted to go ahead and bring it up to you. So we're going to take a look at what the regulations actually say. Right of possession means possession or control obtained with the voluntary consent of a person or group that had authority of alienation. Right of possession is given through the original acquisition. So I'm just going to break that down for you. The first part that I really want you to pay attention to is that right of possession requires voluntary consent, which means transfer done under duress or coercion is invalid and does not count as right of possession. Relinquishing right of possession must be done only by a person with the authority to do so. These criteria must be met at the original acquisition. Grave robbing and coercion are not valid ways to acquire right of possession. This is important to consider because this means that documents related to donor gifts or acquisition are not necessarily valid proof of right of possession. If an ancestor, their next of kin, or the governing body of their native nation did not give permission for their remains or cultural items to be removed and taken by an individual or institution, there was never a proper right of possession by that institution. Native sovereignty dictates that Native nations have a right to protect and maintain their own cultural items and ancestors. Who is required or may participate in NAGPRA, such as sovereign Native nations, and items protected under the Act are covered in the applicability section. So we're going to be moving on to accountability now. And one of my colleagues will put the link in the chat for the regulations. These regulations are applicable to and binding on all museums, federal agencies, and Department of Hawaiian Homelands, DHHL, for implementing the systematic processes for disposition and repatriation of human remains or cultural items. What's important to realize about accountability is that it refers to not only the party that is responsible for execution of the requirements of the law, but it's also letting us know the party which faces the consequences of inaction or noncompliance. NAGPRA is not a suggestion. It is not just the right thing to do. It is not a DEAI initiative. NAGPRA is a legal requirement under federal law intended to benefit Native nations and protect and restore their ancestors and cultural items. Noncompliance has legal, financial, and even social consequences. If you're interested in learning more about one of those consequences, which is civil penalties, they are discussed in 10.11 in Subpart C of the regulations. So to conclude this section, we would love to give you a break from listening to us talk and to participate in an activity. And we're going to have some scenarios that we would like you to answer. Please put your answers in the chat. They might be as simple as a yes or no, or there might be a little more complicated answer. So don't be afraid and please participate. So does this agency, museum, or institution apply under NAGPRA? The first one is a federal agency has a number of Native American cultural items. So I will give you some time to go ahead and put your answers in before we move into the next one. Remember, what is applicable under NAGPRA? We're thinking of holdings and collections. What does a museum mean? Who must and who may participate? Does this federal agency apply under NAGPRA? Maria says yes. We're seeing some yeses. Yes. This federal agency is subject to NAGPRA compliance. Thank you. All right, the second one. A private university recently received a contract with the US government and has possession or control of Native American ancestors. Is this subject to NAGPRA? Federal funding, that's right. Thank you, Helena. Federal funding, it's not always just grants. It could also be contracts. Yes. And I know that might be confusing because it has the word private, but if they have a contract and they are receiving federal funds and they have a collection with possession or control of Native American ancestors, they would be subject to NAGPRA. Thank you. Yep, follow the money. Thank you, Nick. All right, the third scenario. A museum has custody of Hawaiian cultural items and has received federal funding. Is this applicable under NAGPRA? So I want you to pay attention to some key words here. There's one word in particular that I want you to look at in the third scenario. Yes, Kay, thank you for that. Custody. So while the museum may only have custody of these items, they do not necessarily have possession or control. However, that does not completely negate any participation in NAGPRA compliance. They are required to follow duty of care, which we will talk about in a little bit. So while they do not have possession or control to be able to make those repatriation decisions, they do still have some limited compliance that they must follow. So that one's a little bit tricky. In our last scenario, a state archaeological agency has possession or control of cultural items which are loaned for an exhibit at a museum. Does this apply to NAGPRA? Must they comply? Yes, Megan, it is sneaky. Looking for some answers. So remember, who is a museum? What qualifies them as a museum? Do they have possession or control? Do they have custody? Is the museum involved that has the items that are being loaned? Does the agency receive federal funding? If it's a state, then they most likely receive federal funding, even if it's not related to the actual archaeological agency, the state itself. It's an agency of the state. So in this situation, both of them must comply with NAGPRA. Of course, the archaeological agency that has possession or control, they're going to be the museum that is actually helping make the decisions for the repatriation process. But the museum that has the items loaned to them for an exhibit, they must also comply with duty of care. So if these items were on exhibit, they would most likely have to take them off of exhibit until the consulting parties could give their permission, their free, prior, and informed consent to display them. Thank you all for your participation. Okay. So now you understand where and to whom NAGPRA applies. Next, we get to see how the purpose of NAGPRA and the legal obligations it regulates become braided together in some of the key concepts or definitions that are woven throughout. First, we will cover how the definitions of consultation, native traditional knowledge, and consent are applied in the duty of care provisions. Take it away, Kay.
Thank you. All right, so we've talked a little bit, teased in our little activity about duty of care. So let's talk about it. What is duty of care? The duty of care requirement is one of several obligations or requirements museums and institutions must follow. In short, the duty of care is the safe handling and correct cultural care protocol for ancestors and belongings. These must be determined in consultation with Native nations and lineal descendants, with consideration for Native traditional knowledge, and it is grounded in free, prior, and informed consent. It's important to note that in this specific section of the regulations, these definitions are very specific to duty of care. I'll point to these specifics as we break down each piece. So the first requirement of duty of care is to consult on the storage, treatment, handling of ancestors and belongings. While the definition for consultation broadly covers the entirety of the law, it is very focused here on what the duty of care is. which is, in short, a set of agreed upon instructions and protocols for caring for ancestors and belongings while they await their eventual return. So storage. This area of questioning is where we ask, how should ancestors and belongings be stored or housed? This includes materials for packaging, the design of the packaging, orientation of the packaging, visibility, and any other storage preferences asked for by the Native Nation. Treatment. This is where we ask what treatments are needed, as well as what treatments have already been applied in the past. So this would include discussion on the use of harmful chemicals used to treat ancestors and belongings. I know many of our people at the conference know a great deal about the use of harmful chemicals in the past procedures for curating. But for anyone that doesn't know, many ancestors and belongings were unfortunately treated with harsh chemicals that are toxic, both to those who are still interacting with them and caring for them, as well as if there's intention to rebury, there needs to be consideration for the ground and the soil surrounding those ancestors as they are reburied. So this part of the discussion is really important to disclose. So that, as mentioned, it includes the past, but also current and the preferred use of pesticides, humidity control, and risk management for caring for the collections. There may be requests here, such as smudging in this area, and that is also considered a treatment. And the third piece is on handling. How should ancestors and belongings be handled? A general best practice is to limit handling as much as possible. Consultation should determine handling procedures and cultural protocols that must be followed under duty of care. For example, this may include gendered protocols for handling some ancestors or belongings, and they may only be handled by certain individuals at specific times. So as an example, in my own community, we practice moon time protocols. Moon time meaning menstruation. And during menstruation, women are not permitted to handle sacred items or belongings. So for me, as an archaeologist and someone who works in collections, I follow this for my own personal safety. That's just one example of many that might come up in these kinds of discussions. Another thing that's important to bring up here in these discussions is emergency situations. Imagine what happens if there's a flood that happens in the curation facility or where ancestors and belongings are being stored. Can you reach an agreement with Native nations you are consulting with as to how to proceed if those emergency situations come up? And also ensure that you're disclosing, if you're a museum, institution, or agency, what policies and procedures you have to follow as part of that agency or institution. Oops. Here we have an example of what kind of duty of care requests a Native nation might make. We formatted it into a very simple Word document of bullet points. So a nation could create this kind of document to have pre-prepared to share for consultation, or you can develop a duty of care expectations on a case-by-case basis. Whatever suits the Native nation's needs best. This is one of several parts in NAGPRA where Native nation sovereignty is center stage. The museum, institution, or agency must do their best to accommodate the nation's request within their ability to do so. Duty of care requests can be made via a document like this with official letterhead, verbally, or via email, whichever format the Native nation prefers to communicate. The third part in duty of care is consideration of Native traditional knowledge. So the second requirement of duty of care is to make a reasonable and good faith effort to incorporate and accommodate the Native American traditional knowledge in the care of ancestors and belongings. This is again where the definition of Native traditional knowledge is narrowed in its application under duty of care, with the use of the language reasonable and good faith. So, because we are new to this kind of language, we're going to have another little activity. We'll give you 5 minutes to type into the chat. What do you think a reasonable and good faith effort means or looks like? I know it's a meaty question, so we'll give folks time. Shannon says not unusual, not bad faith. Megan says fair and considerate, not seeking gain. Yeah. Basil, thank you. Meeting in the middle, sometimes when a museum has certain policies for preservation, such as pest control. Yep. Nick says, follow the instructions given as close as you can, knowing that there may be situations where you may not be able to follow them 100%. Yeah. Lisa, consultations, oftentimes many consultations. Yep. Listening. Yes, active listening is so crucial to this process. Bailey, coming as close to fulfilling tribal requests within the institutional constraints of time, budget, and personnel. Yes. Dita, consistent, timely outreach and follow-up with any and all potentially interested parties. Yes. The due diligence to ensuring you're contacting each and every person who might need to be involved. Abby, who gets to define reasonable and good faith. Is it whatever nations decide? Yeah. There's also very basic definitions for what reasonable and good faith is. Kirsten says, considerate, relevant, respectful, ethical implications. Yes. To work with the tribe and provide the care that they are requesting for their belongings and ancestors, and finding solutions for requests that may not be part of museum standards. Yes. Thank you, Lisa, for finding the definitions. Yes, reasonable within the capabilities of the institution. Yeah, good faith, make a wholehearted, meaningful attempt to complete the request. Yes, so essentially, good faith is this honesty in fact, so it requires sincerity and the absence of malice or design to defraud. It means honesty in fact, and observing reasonable standards for fair dealing. And then reasonable effort or standard is actions deemed objectively logical, rational, and appropriate in the given context. So to go to your question, Abby, on who gets to define reasonable and good faith, it is the Native nations through consultation in determining that. And it's also through that collaborative work between museums and Native nations, because we also heard through many of your comments that the red tape of institutions themselves can kind of limit your ability. So while a nation might say we prefer for belongings to be kept in a circular room, there might not be a circular room on campus that can handle these sorts of things. Like those kinds of requests, as much as people can do to meet those requests for duty of care as appropriate and within our scope, that's really determined through consultation. Thank you all. And then the third piece under duty of care is free, prior, and informed consent. It's also often called FPIC or FPIC in short. And it's not just a definition that applies here, but it also applies in many other areas of the law, as we saw in our previous discussion on the right of possession. So what is free? Free means without coercion, intimidation, manipulation, and it should be self-directed by the affected nation. What is prior? So it means consent must be obtained before any activity begins. So you'll call back to us discussing that discussion and consultation on safe handling and storage and care for belongings and ancestors. It's good to ensure that you've talked about emergency situations. That way, that free, prior, and informed consent is given before that emergency situation arises. What is informed? So the receipt of full disclosure of information about the activity, including its nature, size, scope, duration, who benefits, and other impacts. So in using the emergency situation as an example, this would be, following that emergency, we would expect that that institution would provide full description of what had happened, what was taken to continue duty of care throughout those that process would come in that informed piece. And then consent. Consent here is a collective decision as sovereign native nations. And sovereign nations have the inherent right to give or withhold consent. I'm just looking at the chat. Haley put a really good thing in the chat, says, within the capabilities of the institution, in quotes. It is within my capabilities to go to seek out the resources needed to accommodate a request, further instructions, funding, etc. Yes, yes. So it is important to note that free, prior, and informed consent is the bare minimum. It is the heart of this law, as it reminds all of us that doing repatriation or rematriation work, that consent was never given for those ancestors and their belongings to be looted, studied, and put on display. But we are doing the reparative work to ensure that consent is always a priority in our present and future relationships. And now, if you ever have a question regarding specific terms like these, my colleague Basil will help point to where you can go to find out more information.
Thank you, Kay. So duty of care concludes section 10.1 of subpart A. So if you're still following along with us, we are now at 10.2, where we're provided with all the definitions relevant within the regulation. So in Winter's earlier discussion, they pointed out how useful and vital the definition section is within a law. The meaning of a term within a law is specific to that law. It's important to familiarize yourself with NAGPRA specific definitions and not to rely on what you think a word may mean. A really good example is the term museum. A museum under NAGPRA could be a state archaeological society. It could be a university. It could be a lot of things that we out beyond NAGPRA might not consider a museum. So we have to make sure we're returning to that definition that NAGPRA provides for us. So we've already touched on some of the important definitions you need to be aware of, and we'd like to do a little activity to get you experienced in exploring the definition section. So what we'd like you to do now is please follow the link that we're going to share in the chat. And take a look at the available definitions. When you find a definition that you didn't know until now, please share it, the term in the chat. You can also share something that surprised you about the definition, something that you find unclear or confusing about the wording, and you can even share a term that you feel has not been defined and should be. I can start with, I sort of mentioned earlier that I find the possession/control versus custody definitions a little bit wordy and confusing. And that's when it's really helpful to sort of have examples to bring to mind that give you a little bit more clarity.
Yeah, and I'll hop into while folks think about their responses. I think one definition that I often go back to, especially in my research outside of my work with the association, is the objects of cultural patrimony definition, because through that definition, I've learned there are layers to definitions. Like oftentimes you'll find one definition and it has a bunch of other words that are also in the definitions that you have to go find and go digging for to finally have the full picture. And it was really through like trying to understand what an object of cultural patrimony was that I realized just how important it is to like really go back to the definitions and keep reminding myself what each little word means, because every single word is important and intentional. And just Googling the legal definitions like we did with reasonable and good faith is a good example too of like in the legal world, these words mean very, very specific things. Shannon says the United States means the 50 states and the District of Columbia.
And as I said, you can also throw in a word that you wish you were seeing here. A big point of conversation when they were updating the NAGPRA regulations was, deciding what would stay and what would go and what needed to be included. And you'll see in the final rule that sometimes not everybody agreed, on what we really needed, but they still had to come to a decision in the end.
Cheyenne says a better definition of research would be useful.
Mm-hmm.
I'm just going to pull up the regs so I have them. Yep. Research is defined in several areas, and the one area where it's defined that we just talked about is duty of care. And it says that research includes, but is not limited to, any study, analysis, examination, or other means of acquiring or preserving information about human remains or cultural items. Research of any kind on human remains or cultural items is not required by the Act or these regulations, which I know, Basil, you'll be talking about soon.
Mm-hmm. Abigail says, I wish there was a definition for exhibition. So do images online count as exhibition? That's a really great point. Are we talking about physical exhibition within a museum? Are we talking about online? And so on. And Shannon says, yes, it does. But, you can never have too much clarity. I think some people would agree. Mm-hmm. Yes, Shannon says, a broad term is defined broadly. So it sort of helps fill in those gaps. When we have specific questions like that, we can say, okay, well, if I was thinking about this under a broad umbrella, would it fall under it? And then the answer is yes.
Melanie says the very narrow definition of a sacred object. I think the important piece in regards to especially when it comes to the objects piece, is that each one is nestled under Native traditional knowledge and consultation. And so each of those can only really be defined through consultation, and Native American traditional knowledge is considered expert opinion. So I think that's where that narrow definition in the regs can be made broader through consultation. But it's really through consultation that determines where those belongings and ancestors fit.
Okay, so I think we can move forward here, but as we said, we'd encourage you to keep going back, returning again and again to the definition section, because they are a tool for you. And it's sort of, as we said here, when in doubt, check the definitions. So one of the terms you come across while reviewing the definitions is cultural affiliation. While it's defined in 10.2, cultural affiliation has its own dedicated section in 10.3, which outlines the process for making cultural affiliation determinations. So if you're following along with us, we are now at 10.3. So what exactly is cultural affiliation? Cultural affiliation, defined in the NAGPRA regulations, means that there's a reasonable connection between ancestors or cultural items and a Native nation or Native Hawaiian organization based on a relationship of shared group identity. Cultural affiliation must be determined by the information available, including information provided by a Native nation or NHO, and cultural affiliation does not require exhaustive studies, additional research, and we already learned what research may cover under duty of care, or continuity through time. Cultural affiliation is not precluded solely because of reasonable gaps in the information available. Cultural affiliation has its own section, as we see, because it is so important, because it's cultural affiliate determinations that must be made in order to facilitate repatriation or disposition, which is that goal of NAGPRA. So what does reasonable connection mean? So again, we're seeing the use of this word reasonable. Reasonable, as defined plainly, means accordance with reason, not extreme or excessive, moderate or fair. Meaning, as stated in the regulations definition, a reasonable connection does not require validation through exhaustive research or continuity through time. This language was changed during the 2023 regulation, which had an update which replaced a preponderance of evidence language with reasonable. The DOI determined that the preponderance of evidence had been misused and misapplied in determining cultural affiliation in the past. And the use of reasonable connection prevents unnecessary barriers to repatriation. The use of reasonable is considerate of the nature of Native traditional knowledge as being represented in many forms, not all of which are traditionally considered valid by Western legal or scientific attitudes, as we learned from Kay's previous sharing of the story of the Great Beaver. When we revisit the purpose of NAGPRA, we are reminded that the priority is to protect and restore Native ancestors and cultural items, consult with Native nations, and defer to Native traditional knowledge. Cultural affiliation made through reasonable connection supports this purpose by not creating unfair or excessive obstacles for Native peoples and creating a more accessible pathway for restoration and protection. So cultural affiliation this determination is made by following 3 steps. So remember, in the purpose, we were told that we were going to be given these systematic processes for everything, and cultural affiliation is no different. We have these 3 clear steps to follow. So starting with step 1, the institution must collect information available. Kay, do you mind going back? Thanks. A museum, federal agency, or DHAL must collect information that it has for ancestors or cultural items. So you can see by this bulleted list some of the types of information that you might gather, and this is just some of the options. This isn't a limited list. And where can you find this available information? So it could be found in collection records, catalog cards, labels, reports, publications, forms, and so on, anything you can kind of imagine being within the records of a museum, and most importantly, during consultation. So what we'd like to do with you today is dive a little bit deeper into this step 1 of cultural affiliation process by working together to collect some available information. We're going to do this based solely off a museum's catalog card. So take a look at this fictional example of a catalog card that a museum might have. If this was all the museum had available to complete step 1, what information could be pulled from the card? And are there any observations that you make while looking at this card that you think are important to bring up? So Kay says that this card provides us with the collector's name. So we see that this was given by a George B. to the museum. It's a good point. You can sort of follow the rabbit hole for George B. Melanie says, knowing the geographic location of the Apple site. Lisa also says the Apple site, the donor's name, Maryland. So Maryland gives us some geographic information that might be useful. Kirsten says the site, the type of items, the dates are useful as well. Dita says it's likely a processing site if multiples of each item type were found. So you might be able to find that this Apple site is actually a registered archaeological site. Maybe there was a pretty robust excavation that took place. Yes, and Lisa brought up the animal bones question mark. And Abigail also made a really important point that human bones have often been confused with deer bones. So you're gathering information available here, but you also should have some of those red flags popping up. Remember, our duty of care expectation, with this collection is that the museum, without consent, cannot do further research. Now, they see from this card that there is bone present that may or may not be human. It may or may not be animal. Their duty of care obligation here is to pause, make sure they're letting the nations that they're consulting with know that there is bone present, and it is up to the Native Nation if they want to look into that further. Do they want to do any sort of further study or research? That's not for the museum to decide. Their obligation here is to make sure that they're transparent about the presence of bone and then decide in consultation what the next step is going to be. Emily says, when all else fails, I would see if the shell-tempered pottery or red shirt have a general area of use concentration for geographical link. That is a really great point. Sometimes you might look at something and say, I don't see a state name. I don't see any of these geographic giveaways. Well, if you can make a connection that says red shirt is quarried in this very specific geographic region, you might be able to narrow it down. So this is great. Everybody's coming up with some really great points. And you see, all we have here is a card, and you can see you're pulling out all this great information. Lisa says, I do this all day long. Me too.
I am noticing that we have a lot of maybe potential archaeologists in the chat as well who are hopping in and saying that because it's from the surface that it might be from a more recent period. But it's important to note that NAGPRA doesn't particularly care about time frame in terms of how old or how recent a belonging or ancestor was removed. All that we care about is that it was removed from a place that has people who have homelands in that area. And so it's only through consultation that we can get more into the nitty-gritty that you're bringing up. And I know it's hard as archaeologists to not immediately go down the rabbit hole of trying to figure this information out, because that's what we're trained in. But when it comes to NAGPRA, that's not our job and that's not the purpose.
So thank you, everybody, for your great input. We can move on to the next slide, where I've just covered a lot of what we've already mentioned. So, you have a date here for any of our museum people. You know that sometimes a date will lead you to more and more documentation. We have that geographic source of the material. Here we have the temper for the ceramic sherds, which might be connected with an earlier group. And as we mentioned, the sort of red flag that pops up here is this presence of bone, and how the determination of the next step for this can only be made during consultation. And we can move on. So now take a look at this catalog card. We're not going to pull it apart like we did the other one. You can still think about it that way and what you would do. I just wanted to point out that the information you have available might provide insight into what process the museum must follow and other information, important information they need to be aware of. So here again, we see the word bone. This suggests that an ancestor may be present, and this informs the museum about the type of holding or collection they are in control of and what processes they need to follow in Subpart C. Earlier, we mentioned that it's important first step to determine if your museum is in control of a holding or collection or has custody. So on this catalog card, we can see that the donor was an Army Corps employee. This can be another red flag that pops up because it might be suggesting that a federal agency is actually the controlling party. And the information available also provides the museum with that crucial starting point for initiating consultation. So in this card, in the last card, we've seen everybody brought up again and again, look at all this geographic information. And that is very often going to be the clearest starting point for you for initiating consultation and understanding which nations to reach out to. So a question that does come up is, what if there is no available information? I have this in quotations because I think we can all agree that it's very unlikely that a museum is unable to gather zero information on a holding or collection. And when it comes down to it, even the geographic location of the museum itself, the state or the city that it's in, can be useful as a starting point for initiating consultation. Remember that consultation is the most crucial part of this process. You need to open that door, start having those dialogues, and that is going to lead you to further information. So even if it feels like you don't have anything except, one grain of information, you have enough to get the ball rolling. So here we have some quotes from the regulations. As we saw earlier in that definition of cultural affiliation, a lack of any type of information does not preclude a termination of cultural affiliation. So lack of information can never be used to prevent the determination from happening. And additional information may be provided by Indian tribes or NHOs. So ultimately, consultation will provide any further information needed to determine cultural affiliation if additional information is needed at all. So step 2 for determining cultural affiliation is identifying the required criteria. So using the information we just gathered available, you initiate consultation, you have these consultations, and you now must identify the 3 criteria for cultural affiliation. So we have 1, identify an earlier group, 2, one or more Native nation or NHO, and 3, a relationship between 1 and 2 that is reasonably traced through time. So it might be helpful to think about cultural affiliation as a branching tree, which I think is a familiar example used when people think of things like ancestries. But we want to think about it as a branching tree with all its natural imperfections. It's natural. It's not perfect. The use of reasonably traced through time is really crucial language in step 2, because it acknowledges that while clear branches throughout time may be preserved, it's also common for breaks in continuity and diverging paths to exist because of the impact of displacement and dispossession on Native peoples. Again, the use of reasonable is for the benefit of Native peoples and making repatriation and disposition actionable. The NAGPRA process no longer uses the term culturally unidentifiable, which was introduced in the first iteration of NAGPRA to refer to ancestors and cultural items which a museum determined have no possible affiliation. This term was unjust for once-known ancestors and belongings, and it gave museums the opportunity and the out to avoid meaningful consultation. The emphasis that's now placed on Native traditional knowledge and the ability to affiliate based on geographic information in the regulations confronts this past discrepancy. So here we included an image of a budding plant. to suggest that it can be thanks to meaningful NAGPRA consultation that once known ancestors and belongings are known again, and consultation and these connections can be made revealed through consultation. And the final step for determining the cultural affiliation is to make a determination of cultural affiliation. It can be clearly identified, reasonably identified, and in very rare cases, cultural affiliation cannot be identified. The museum must share cultural affiliation determinations in notices by the deadlines that are relevant to the process they are following. So when you get a chance, explore Subpart B and C further to see specific deadlines. And National NAGPRA provides some great templates for the notices that you need to create whenever you get to that step. Affiliation can be made to more than one nation or NHO, and it can be made to a nation and a descendant in tandem. So this would lead to a joint disposition or repatriation. So we just went into depths on Subpart A from 10.1 to 10.3 of the regulations. So thank you for sticking with us. We know it's a lot of information, and we hope that you now sort of know where to look when you have questions about the purpose and applicability of NAGPRA, and you have some time to dive a little bit deeper into the definitions and the key terms. A major theme that we kept revisiting was consultation. So consultation is not a one-size-fits-all approach, and it may happen differently depending on the circumstances of the consulting parties. So before we have a general final question and answer session with everybody here, we'd like to have a discussion on the important cornerstone of the NAGPRA process, which is consultation. So a prompt for everyone that we have here is, what are some best practices if you already have some NAGPRA experience for consultation that you have picked up in your experience? Yes, if you'd like to speak, feel free to let us know, and Shannon will get you set up. Kay made an important point that active listening is really valuable during consultation, but what does active listening mean or look like?
And I'll hop in and discuss just because I can't stand the silence. Yeah, I think that one, thank you, Basil, for picking up the pieces on the consultation piece. I think that, as was mentioned before, and what I mentioned in the chat, is this idea of active listening. And something I see time and time again is that I work in a community-based way within my own community of Potawatomi people. What we call active listening might look very different from person to person, and often what I've seen is it does. And I'll pause. Cheyenne says, keep following up with your tribal partners until they tell you otherwise. Yes. Not assuming someone is uninterested in consultation just because you sent one email. Yeah, consultation never stops. You're always checking back in, making sure that your emails aren't bouncing or somehow being rejected. There's also a million different ways to contact people. You can call them, send them physical mail, or email them, or do all of the above. Yeah, Shannon adds, don't just send one email or call once.
Kay, I think you brought up a really good point that active listening may not look the same for everybody. And so leading with curiosity and asking those questions up front about what respectful communication looks like, I think can be a really helpful practice to begin with.
Yeah, and I think an important point that Isaac brings up, and that is ceremony and prayer, listening and following up and follow through. Most of the lessons that I've learned in active listening and knowing what active listening means and looks like is through demonstration and ceremony, from being in ceremony within my own community. I look a lot to my own elders for what active listening looks like, and as teachers to know how to move through those spaces. And many elders are involved in repatriation processes too. And so listening with respect also means silencing your headspace, which can be really hard. You're not thinking about what to say next or how to respond. All your processing is the other person's words, really listening with intent. We're also taught, at least in my community, that listening involves more than your ears. It involves your body, the way you acknowledge the space. So if you're one of those people that like to take notes the entire time, make sure you're pausing to really just listen. Taking notes can feel like a separation between the people you're having a conversation with as well. We know documentation is a really key part of the consultation process, but you don't need to write everything down. And if someone's teaching you or teaching or talking about Native traditional knowledge, it might actually be a best practice to not write it down. That's a way of making sure that we're safeguarding and protecting any traditional knowledge and confidential information.
Ellie put a really important note in here that I want to echo. When you're working on the museum side, putting away all defensive urges, learning to be comfortable with uncomfortable situations. And it's a practice. It's something that going into it, you might, your shoulders might be up, you might feel defensive, you might feel on edge, and to do your best to let that go. And that's a part of active listening as well, to let down your defensive walls. Don't be afraid to be uncomfortable. Don't be afraid to say the wrong thing, and be prepared to be humble and to apologize and to correct yourself when those things happen. And that we all sort of meet each other in the middle, human to human.
And I think with
says our relationship protocols. Very good.
I think with the newer regulations, it also, you spoke about being humble, Basil, and I think it's important to remember even the people with years and years of experience, the regulations change the way in which we do repatriation. And I know just as a lifelong learner that there's always something more that I can improve. There's always something that I can learn, even if I have expertise in one area. I'm not going to understand all viewpoints just from my lived experience. And so it's really important to lead with curiosity, even if it's something that we don't necessarily agree with just right off the bat.
Mm-hmm. We've got a lot of great sharing in the chat. We really appreciate that. Victoria says, when in person, ask questions about accessibility needs before tribal representatives arrive. I think it's very important to, make sure that those questions are answered, not on the fly, but in the before things start, being prepared and being considerate. Coffee and snacks go a long way. And on the same note, Maria says, hospitality and welcoming to the tribal members as you would friends and family. Absolutely.
One thing that I did want to bring up was in terms of hospitality and accessibility is also thinking about social accessibility. And I know sometimes it might feel beneficial to include Native American employees during more difficult times, but if a museum is going to include Native American employees during difficult conversations, they should also be included in conversations that are not as difficult. This work requires a lot of emotional labor. And if you remember in our discussion of traditional knowledge and deference, that there's a difference in worldview. So there's information and impacts that not all museum practitioners may realize that are on the back end for Native American practitioners. And making sure that we're not just loading the emotional labor on Native American employees and consulting parties is a really important consideration to make from the beginning of how you can make your space socially accessible and comfortable for your guests who will be consulting with you.
Absolutely. So we want to transition into opening up Q&A. So thank you everybody who shared that we didn't get to. Make sure you're taking the time when you can to read through the chat and get everybody's insight. But now we just sort of have open Q&A. So if you have any questions about Subpart A, about Native sovereignty, about what we've taught today, about us, please feel free to share.
Thank you all. Everyone, give some hands and some shouts to our presenters, Winter, Basil, and Kay today. Thank you all so much. We're going to get into the Q&A, and I'm going to read the first question from Abigail Thompson. How do images of physical belongings and associated records fall into the 5 NAGPRA types or categories? I presume this is defined by Native nations through consultation. Who'd like to take that?
Could you repeat the first part? I'm sorry, Shannon.
You betcha.
Thank you.
So the first question is, how do images of physical belongings and associated records fall into the 5 NAGPRA types or categories? So how do they fall into the definitions of cultural items and ancestors? How do images fall into definitions of cultural items and ancestors?
So this is my personal opinion on it, that data that has been taken from ancestors and cultural items when there wasn't free, prior, and informed consent, I personally feel that research shouldn't have happened in the first place. Because the museum or federal agency did not have right of possession over that ancestor or cultural item. And while photographs and other types of data may not be required to be repatriated, they can be repatriated and they can be put into inventories and sent along with it, with the ancestor, or for summaries and cultural items. Of course, excluding associated funerary objects, which are to be included in inventories. So there's nothing barring museums and federal agencies from repatriating that data from research that was done without free, prior, and informed consent. And if we're thinking about long-term and not just NAGPRA, if we're thinking about the types of relationships that you want to have with Native nations, if we're thinking about the type of values that an institution says it holds and practices by, then morally and ethically, it would behoove the institution to repatriate that data. Also, from my class with Shannon at Johns Hopkins, I learned that you're not supposed to take pictures of cultural items without consent. So that would be like exhibiting the item and
you're not supposed to exhibit items without free prior informed consent. So using them in presentations without the consent of the consulting parties would also be not really best practices. And so I would really, even if it's not a exact requirement under the law and the new regulations, I would also consider in the beginning of our conversation, the topic of native sovereignty and also the type of relationship you would like going forward.
Winter, do you mind if I step in on that question a little bit?
Please do.
And to help kind of just make it really short and brief. So even though there may not be a requirement in the definition of research that those items get repatriated, if there are those items and the tribe defines those items as an object of cultural patrimony, as a sacred object, as a human remain, because it's been extracted from those types of cultural items or ancestors, then the institution must defer to native traditional knowledge and the meaning of what cultural items is. So then it would be an issue of requiring repatriation of those images as a cultural item as defined by native traditional knowledge. So I would not say, Winter, that it's not a legal requirement, because once a tribe says this is our traditional knowledge, that anything extracted from the sacred object is the sacred object, then the institution may be on the hook to return those items that have been extracted from the sacred object. So are we ready for the next question? Mm-hmm. Thanks for that question, Abigail. The next question from Haley Lorenzen. Could Native nations request previously collected information, photographs, documents related to ancestors or belongings to be destroyed?
I think the simple answer to that one is yes. I think that has to be like done in consultation, right? I think there's also a lot of precedent. I'm sure there's people in our audience right now who have been in consultation where that's been a request that's been made. So yeah, Native nations can request them to be destroyed. They can request for them to be taken down. They can request for them to be sealed. They can request for property rights to be returned. Anything the Native nation could imagine in terms of what is in the scope of possibility, a Native nation can request to happen with the information relating to ancestors and belongings involved in that repatriation. So it also gets into the conversation we had before on photos, and that photos could also be part of that, as well as, you know, if they're determined by the Native nation to be extenuating like documents or research, as opposed to them being the object or the ancestor or having the spirit of those ancestors or belongings. So whether the Native nation argues one way or the other, they're under the sovereign right of that Native nation.
And both of those questions, I think they really go back to the importance of remembering that deference is in the purpose, which applies to all areas of NAGPRA and not just Subpart B or Subpart C.
Shall I move on to the next question?
Yes,
okay.
Please.
From Emily McDowell. Going back to definitions, a recent community of practice discussion addressed the topic of lineal descent. I believe Winter and Shannon were significant contributors to the conversation. Can an individual claim lineal descent for objects of cultural patrimony that retain ongoing cultural significance to a collective group? I noticed in the definition of lineal descent, objects of cultural patrimony are not mentioned, which feels intentional, though I may be overthinking it. So shall we look at the definition of those things before you answer the question?
I'm on the link. I'm going to post in the chat for you.
Mhm.
So lineal descendant is defined in the definitions 10.2, and it's everything is defined alphabetically. And if you look at, has anyone just cut and pasted that into? The very first part under lineal descendant says a living person tracing ancestry, either by means of traditional Native American kinship systems or by the common law system of descent, to a known individual whose human remains, funerary objects, or sacred objects are subject to this part. Yes, it was an intentional removal of cultural patrimony. Why is that? If you look at the definition of what an object of cultural patrimony is, you'll see that it's defined as kind of being owned by the nation or the community. So just by the definition of object of cultural patrimony itself, it limits it to the nation instead of a lineal descendant. So a lineal descendant couldn't have a connection to an object of cultural patrimony, because an object of cultural patrimony is only connected to a nation ownership, the community ownership, not an individual person that's been carried through family to family to family or through their kinship systems.
One example that I like to use, a pop culture reference, is that so with the Declaration of Independence, Nicolas Cage could not, in fact, sell or privately hold the Declaration of Independence. He does not have the right to alienate it. He does not have the authority to do so.
Yeah, excellent. Great example. So we'll move on from Nicolas Cage to Helena Pagano's question. Places still do not understand the new NAGPRA updates from 2023. I guess if I had to ask a question in relation to that, how would you approach that? Thanks.
So this question, I have some conflict coming up because for me, I like to assume the best out of everybody at first, but I've learned that not everybody has the same idea of what it means to be good or to do the right thing. And so I like to rely on compliance, that, as I had said in the beginning, this is not a DEAI initiative. This is not just the spirit of the law and building relationships. This is legal compliance with real consequences. So not only are there the legal consequences, which involve civil penalties, or cases could be brought up against the institution. There's the possibility of losing the public's trust. And museums are public institutions that are serving their communities. And without the people, without the people's trust, it is a repository and storage space for things. But our connection, our humanity to those objects, that's what makes them culture, right? Our interpretation of them. And so there are real life impacts to not following the law, because it is indeed a federal law that they are subject to. So if they're having a hard time understanding the regulations and the fact that they need to comply, I think on a very just basic level, helping them understand that they have no chance, they have no option but to comply is really important foundationally.
I also think this question is not the first time I've heard this question or like heard the statement. And I'm sure many of us are in the same boat. I find it ridiculous for anyone to know on the back of their hand every single line of this law for the rest of time. Whether the regs change or not, you should always be going back to the regulations and the act. Like, I know I'm a new learner and I have the regs and the act pinned to my screen at all times, so I know exactly where to go. That's not going to change. Like, I don't see that changing 10 years down the road, even if these are the exact same words 10 years down the road. It's always good to ensure you're going back and rereading, and it's ridiculous to expect anyone to have it memorized. And so for museums that it seems clear to Native nations aren't following the law, that's where we'd probably direct you to look at the civil penalty section to see what might be available to tribes, Native nations, to ensure that museums are complying. Because as Winter's saying, there are ways that you can push for compliance. Good relationships is always the best route of action, trying to get that first foot in the door to continue having conversations is important. But if they aren't responding or they aren't really complying with what the regs say, then there are other options.
Well, we've come to the end of our time. Shannon Harley put in a question right at 1 o'clock that has to do with federal recognition and nations that are not federally recognized. There will be a panel on Thursday about nations that are not federally recognized in NAGPRA. So we invite you to come to that. And the answer is a bit complicated. So one way that state tribes can work in NAGPRA is through working in partnership and collaborating with federally recognized tribes. Unfortunately, the Department of Interior has restricted the definition beyond what Congress had originally defined Indian tribe to be. So there are some complications now with the definition of that. We really appreciate y'all's time. Is there anything closing that you all want to say quickly before we say goodbye and go on to the next session?
I think the one thing that we didn't get to add is we do have a resource document that will have every single link we've shared in the chat ready for you. Will probably be posted later today or shortly this afternoon. And we'll post that in the NAGPRA Learning Lounge. And I'm also going to go ahead and hop over after this straight into the NAGPRA Learning Lounge. So if you want to continue to have this conversation, that'll be open for you to have that conversation with us. And then on Thursday, you can hear us yap some more about what we've learned as newbies to this stuff and not so newbies to this stuff. And we can talk a little bit about kind of the complexities of what it means to learn NAGPRA.
Thank you, Kay.
You're welcome.
I wanted to take the time to say thank you to Shannon and Basil and Kay for all their hard work and their commitment to NAGPRA and protecting and restoring ancestors and cultural items. And thank you everyone in the audience who is also committed to the same.